Thank you, Dr. Amna, for your generous introduction. My good afternoon to all of the persons who are present and to my two worthy colleagues sitting on the dais with me, of course, on virtual mode, Mr. Chandok and Dr. Vishwanathan. This is indeed a pleasurable moment that Legal Era has organized this sixth insolvency summit. On the completion of 5 years, sixth summit means that from very beginning, Legal Era is associated with this IBC law and has been taking, or rather, I would say, preparing the financial statements or annual statements and balance sheet of the working of IBC and recounting it and deliberating on it every year. And this is really a matter of congratulations. But why I say so, there are hundreds and thousands of laws which have been passed by the parliament, which are functioning, and the enforcement of those laws is taking place at the executive level and ultimately at the judicial level. Cases are decided. But why so much importance to this IBC? Uh, Actually, if I may say so, Mr. Chandok and Dr. Vishwanathan have already said enough about it, and there's hardly anything which remains to be spoken. As Dr. Vishwanathan rightly mentioned, the connect of certain laws with the economics, and I would not say only the economics, but it relates to the economic progress of the nation as well. And when we take those laws and we put these laws into a separate bucket or the bouquet of these laws, I think IBC would would steal the limelight. Therefore, I first must congratulate Mr. Vishwanathan also at this stage, who was the chairperson of the Bankruptcy Law Reform Committee, which gave this wonderful law, prepared this law, and ultimately which was passed by the parliament. As we know, and Mr. Chandok has already said, that Insol India has been in the field of insolvency, and I think it was set up sometime in 97 or 98. So when these things about insolvency, these kinds of talks were not there in India at all. I still remember having attended as a judge of Delhi High Court when I was appointed in July, and my first Insol International Conference I attended within few months thereafter, that is in October 1999, which was held in Munich. And thereafter also I have attended many such conferences. But initially I was totally at sea. And when I attended that conference, I was just wondering what is happening. Of course, Insol India had come into existence by that time, but we were only in India talking about the archaic, which are now archaic laws of SICA and DRT, etc. Uh, and that was one forum and those international conferences which gave us exposure, and they rather gave us some direction also, some guidance also, how to take forward uh, Insol India in this direction. And I must congratulate Mr. Chandok, the way he worked in Insol India, and we started that moment of insolvency regime, legal regime, which should be set up. And ultimately, it was fructified, though very, very belatedly thereafter, but in the year 2016, when this IBC was passed. But what I wanted to say here was that we talk of the in the era of globalization and in the era of liberalization. We talk of foreign direct investment into India. We talk of India as a which should become the prime country insofar as economic progress is concerned. And we are talking about 5 trillion economy in next few years. But in this whole process, there it's not only the efforts which are needed at the government level, but the laws which give impetus to this kind of growth, they are also needed. UNCITRAL has been coming out with such laws, and when we talk of globalization, the convergence of laws is one of the important aspects, which has to be kept in mind, and therefore the laws have to be in consonance with what is happening around the world. And UNCITRAL had come out with the model law on insolvency also. Of course, it talked about the cross-border insolvency primarily, but it was way back in between 2001 to 2004. And the primary objectives behind this law, which the UNCITRAL had stated, all those are kept in mind while enacting IBC. And there, the far-sightedness of the Bankruptcy Law Reform Committee has to be appreciated. If I may say so, in brief, that we wanted, we had some, fragmented laws. We had SICA, we had DRT, we had SURFACE, we had Companies Act, where some of the provision relating to insolvency were there in presence in all. But we didn't have any comprehensive law on insolvency. So that is the product of the IBC. Then the experience showed, and we were always struggling while executing or implementation of the earlier laws, balancing between creditors' right and rehabilitation. On the one hand, the creditors' right; on the other hand, it was always perceived that the earlier laws were, in a way, driven in favor of the debtor. It was the debtor regime, and we wanted that instead of debtor in control, it should be creditor in control, which has been the trend throughout the world, and that is what the this UNCITRAL also had emphasized. But then as Mr. Chandok has also said, and while during the working of these laws, that the main purpose of IBC is not to act as a recovery agent, but it is the balancing between rehabilitation and the creditor's right, where what is to be seen is when, because any cause which is brought before the NCLT, first attempt is rehabilitation in the form of CIRP. And if the resolution fails, of course, in the resolution process, there is a, dynamic shift or paradigm shift by making it a creditors regime. That's a different aspect. But the main purpose is to save the institution or save that particular corporate. And if that doesn't happen, then only we talk of the insolvency or the liquidation, and when this value maximization. And this all has to be happened in a time-bound insolvency resolution process. And so therefore, it is, as far as the IBC is concerned, it takes into consideration all these aspects. Of course, Mr. Vishwanathan has mentioned about the functioning, and he has defended this law. And insofar as the final verdict is given by Mr. Vishwanathan and Mr. Chandok as well, I would agree with the same. Such a law is needed. There may be some teething problems, some hiccups in the beginning. After all, this law is only 5 years old. But can we, if I may say so, in these 5 years, it has made strides. We, India, as India, have been recognized the world over. Mr. Chandok told you that in 2018 or 2019, I think it was, when we were given that prize by some international organization for, bringing about the reforms in insolvency in the country. So we were rated the first in that. And I still remember when this award ceremony was there, and it was said that, look, if you bring the cross-border insolvency chapter also in your insolvency, maybe you will again bag this award, but that is what is lacking. But what I feel is that the entire thirst and the way this, even in 5 years, this legislation has been enforced in the manner, and it has come to this, is that, and Mr. Vishwanathan also highlighted that the kind of government support which is given to this legislation, we have not seen in respect of any other legislation. And it is because this law is directly and intimately connected with the progress of the nation, economic progress of the nation. And therefore, the government has been supportive. And the other factor, which is that there's a planning around implementation. And all the stakeholders, whether these are, if I may say so, the outer side of it, the lawyers who have been appearing, the judges who are manning NCLT, etc., up to Supreme Court, and the stakeholders in the form of creditors and others, and now IP resolution, this IP, this professional resolutions, which are the key elements in the implementation of this law, all have worked in this direction with zeal and with commitment. And that is why, and I should not in the process leave out IBBI and the tremendous work, phenomenal work, which is done by Dr. Sahu in last 5 years, no doubt about it. So therefore, that have been the motivating and contributing factor. The stakeholders have owned up and stepped forward insofar as this legislation is concerned, and the market has responded and supported. So all these factors have been there, and of course, I would entirely agree with what Mr. Chandok said, that it is not a machinery for recovery, but then recovery in any case remains one of the aspects. If rehabilitation fails, as I said about the value maximization, that is again one of the objectives. And if you, I mean, some of the figures which I had seen, according to Economic Survey 2020, the recovery rates of NPAs under IBC have been as big as 42.5% compared to mere 14% under SAFESI Act. So this is a great achievement. And in the case of Committee of Creditors, Essar Steel India Limited, through authorized signatory versus Satish Kumar Gupta, the court paved the way for banks to recover as much as 92% of the total debt in that particular case, which became a historical case. And there has been significant improvement, and the numbers speak for themselves. In insolvency rank, as I said, India's ranking improved from 136 in 2017 to 52 in 2020. And the average time taken for resolution process, which was earlier in 2017, 4.3 years, it has come down to 1.6 years in 2020. So there have been, I mean, many milestones which have been achieved. The debtor in possession from creditor in control, again, this paradigm shift, it has worked well. Of course, it has its own criticism also, which Dr. Vishwanathan pointed out, and I will deal with that very, very briefly because of less time now we have at our disposal. But what I want to say is that after this, I mean, insofar as there is some dispute, or rather there is some debate about whether it has to be debtor in possession or creditor's control. And if you compare the experience from Singapore and India in this regime, of course, Singapore also had this creditors in control regime earlier, which they call it, I mean, from debtor in possession, which they call scheme of arrangement, that is SA. And moving towards judicial management model, this is JM, which we call creditors this thing in control scheme. But then over a period of time, they have also felt that there has to be some balance. It cannot be, because actually it's a very interesting phenomena. Why we came from debtor in possession from creditor in control? Because if the company has come to the brink of insolvency, that is the state of affair created by the debtors. So once the debtors are the debtors in control, sorry, the promoters. Once the promoters are the culprit who have brought the company to this state of affair, why they should continue in possession of the affairs of the company when we are talking of resolution process? So this is one of the basic objective, and rightly so. But what is seen on the other side, I mean, the flip side of this is, which is pointed out by the earlier speakers, and particularly Mr. Chandok said about the responsibility of COC, is that many times insolvency, these professionals or COCs have only looked into from the angle of recovery of what are their debts, and not rehabilitation. And the haircuts, etc., which are given, are also phenomenal in the process. So whether it should be given to a person that to run the company who has no idea about the company, how these companies are to be run in the during the interregnum when CIRP process is underway, and whether they are able to effectively manage the company, that also becomes very, very important when we switch over to this creditor in control regime. So therefore there are I mean the pros and cons of both the systems, and how we work in this is the challenge, which is for the NCLTs in given situation, what kind of I mean the resolution you bring about. Of course, in COC, as we have seen in our regime, again, there may be justifications in when we talk about it in principle, that whatever COC has decided, and if 66%, earlier it was 75%, if 66% vote for resolution plan, then NCLT doesn't have any say in the matter. So whether it should be there, it should not be there, and whether they also should have say, ultimately they should see that resolution plan is in the best interest of not only that particular corporation, but talking generally about it as well, in the interest of the nation as well. But those powers are not there still. These are some of the I mean challenges, apart from the areas, and we know that even when NCLT etc. has been functioning efficiently, NCLT also. And good thing which what I said was that keeping in mind the timelines, and even the Supreme Court, whatever causes had gone up to the Supreme Court up to now at interim stage, the Supreme Court has taken lead not only in removing the cobwebs in the interpretation and advancing the law insofar as IBC is concerned, providing solutions to so many thorny issues by many celebrated judgments, but more importantly, all that has been done in time-bound frame. It's not that, unlike other cases where we say that the cases linger on at various levels for years together, I think every case in the Supreme Court has been decided when it landed within few months, so that it shows or it gives guidance to the NCLT and NCLT also how to proceed further. So these are some of the aspects which are in favor, and at the same time there are some challenges, as I said, in the form of high haircuts, never ending litigation, where in 71% cases the timelines are transgressed, and we have the problem of empty benches, if I may say so very frankly. Of course, recently some appointments have been made, but unfortunately, and Supreme Court had also to come heavily on the government. It is not only NCLT or NCLAT, but many other tribunals where the appointments are not made. But particularly talking about NCLT and NCLAT, where on the one hand we have timelines provided in the IBC, on the other hand, if we don't have sufficient number of members manning these NCLT, then how we do that? And as I said, in Madras Bar Association, the Supreme Court had to come heavily on this. And one other thing which was stated by my both the earlier speakers about MSMEs, and the impression is that in the process they are losing out, and otherwise they are the backbone of any economy, including Indian economy, where MSME sector accounts for 28.90 of country's gross domestic product. Uh, of course, void of cross-border insolvency is there. Mr. Vishwanathan has already talked about it. I won't like to add much, but at the end, and just to finish my talk, I would say that the COVID has, of course, brought many challenges, and many of these challenges are again flagged by my earlier speakers. So, therefore, for want of time, I am not going to go into those details. But the way Dr. Vishwanathan has told about the about big data and use of big data and artificial intelligence, ODR, online dispute resolution, coupled with mediation. So all what I would say is that we need to do everything, and it can't be all these strategies which are available can't be put in separate silos. It has to be combined together, and there has to be an attempt to go ahead. And we see, and there are two very interesting books of one author, this Suskin, who has written about future of law, one book, and other book is online court and future of justice. So where this and what COVID has taught in the process, and the challenges which are thrown to us, and these challenges, to meet these challenges, what kind of automation, what kind of technology has to be used, that is a challenge now, and that would be in NCLT and NCLAT as well, and particularly and including IBB or all stakeholders. And I hope all these challenges which are there would be discussed in detail in the sessions which are going to be and panel discussions which are going to be held. And I congratulate again Legal Era for organizing this and giving me this chance. Thank you very much.